So, Tom, can I begin with you?
Sure.
Thank you.
I thought about doing law at school and then was advised that I should do a history degree instead because that's what actually interested me. I enjoyed debating and I liked the idea of spending my time arguing. So it seemed to me that a life at the bar was probably the right sort of thing to do. I enjoyed formulating arguments and so I went and read history at Oxford. And then after doing that, went to do a CPE at City University. Then I did what was then called a BVc at ICSL, and then I did pupillage at Blackstone Chambers. I was attracted by Blackstone because of the breadth of the work. I thought I would be a public lawyer and thought that I would be interested in mainly doing human rights type stuff, and I liked the idea of doing employment work. That's what I thought I would do. And I'm now really a commercial lawyer. I'm a commercial lawyer for a number of reasons, and I'll tell you about those reasons in a moment. But during my pupillage, I did a mixture of all three types of work. And for the first 5 years in Chambers, you tend to do all of those three. So some public law, some employment law, and some commercial law. And then you can decide to concentrate on two, and I concentrated on public law and commercial law, and now really I do 80% of my time as a commercial lawyer. I mean, why did I choose commercial work? To some extent it chose me. I like the mixture of heavily disputed fact and deep consideration of authority and textbooks. I think if you don't like bookwork, commercial law is not for you. There is a lot of disputed fact, so to some extent you can end up feeling like a criminal lawyer or a criminal barrister, but it's very different because the framework within which you need to apply your facts is one that is very much rooted in law. Most criminal practitioners will not be doing a huge amount of research and a huge amount of case analysis for the purposes of bringing their cases to court. That is what, as a commercial lawyer, I do all the time. What type of cases did I do when I started out as a practitioner, and what type of cases do I do now? As a first-year tenant in Chambers, I travelled very widely. So I would be in Bodmin one day, I would be in Norwich the next, I would be doing cases about whether it was an implied term that the cesspit had to have water added to it by the contractor. I was hated by a number of websites for beating people up over time computers, which were terrible computers that were sold on hire purchase agreements and always went wrong. But I moved up and down the country doing cases in county courts and doing also a lot of work in employment tribunals. What that led me to be able to do was to feel comfortable in court. The danger of commercial work is that you get sucked in as a newly minted tenant into a huge piece of commercial litigation that is going to run for 5 years, that you're going to have at least 3 silks leading you, perhaps 4 or 5 senior juniors, and then there's you, Muggins, in Cyprus, which sounds glamorous, but in fact all you're doing is going through disclosure exercise that makes you seem like a solicitor. What I think is the most important and the most valuable thing of your early career as a commercial practitioner is to feel that you're in court. And that's something that is great fun. You're doing small claims work, but you're out there, you're dealing with mad district judges, you're dealing with mad circuit judges, and then you hope that you will be promoted to deal with mad high court judges. What you get is an excellent grounding in submissions and in cross-examination. But after that, I did a lot more specialisation. I started doing the 3 main types of work that I do, but I was also doing some financial services work, and I still do some financial services work, and it's the breadth of the church within the commercial practice which is amazing. So you can get people who are shipping lawyers, and they are commercial lawyers. You get people who are media lawyers, and they are commercial lawyers. You get people who are fraud lawyers, and they're commercial lawyers. So you can have lots of different food groups represented within the commercial bar. And so if you decide that you like bookwork, if you decide you like advocacy, the next question is what type of commercial set do I go to? And then you need to look quite carefully at the different types of work that the different sets do. What I do is I do three main areas. Traditional commercial work, which is about contracts. I also do media work, and I also do fraud work. An example of the contract type work is a case that I did recently. I was acting for a Canadian aircraft manufacturer. They were being sued by an Angolan businessman who said that his $30 million aircraft didn't work very well, and he wanted to give it back. He'd had it for a year and a half. The question was, did the contract that he bought it under have an exclusion clause that prevented him from giving it back? Was he a consumer for the purposes of the Sale of Goods and Unfair Contract Terms Act? Was a condition, even if it wasn't included in, was a condition excluded even though the word condition wasn't included in the exclusion clause? And so a whole lot of very, very traditional contract type issues that will be familiar to you from your undergraduate law work. We won, they've appealed, we don't know what will happen in the end. That's one area, so that's the contract area. Then I do a lot of media work, and the media work that I do splits into two main types of area. One is I do a lot of work in the Copyright Tribunal, which is a little known tribunal that deals in blue sky issues as to how much should licensors get from licensees in respect of pretty much any type of copyright work. I've acted for record companies and for iTunes in the dispute as to the terms on which online music should be licensed by composers and publishers. I've acted for Record Company Collecting Society as to how much should be paid by music TV channels for the use of music videos. I've acted for ITV as to how much should ITV have to pay for its use of music on its television programmes. And most recently I've acted for the press cutting, in a press cutting agency case. I was acting for the industry body for, or the trade body for press cutting agencies, as to how much should be charged to press cutting agencies for access to online newspaper websites. So quite diverse issues, but with a root in copyright and a root in commerciality. How much should people pay? What is fair? What is a fair contractual term for people to have to enter into in order to use a copyright work? So that's one type of media work. Another type is music work. So I do a lot of work for and against bands in band disputes. And one thinks, well, what's that got to do with commercial work? But most bands are partnerships. So you're having a partnership dispute. A lot of bands have minors in them. So you have undue influence cases. You have overbearing managers who seek to exert pressure on young and formative people. So a mixed bag of legal claims that often involve partnership issues, copyright issues, undue influence issues, and straight contractual issues. The third main area that I do is fraud work. And fraud covers a lot of different types of food group again. You can have employee fraud, people just nicking copyright, nicking information, nicking databases. So you have to go and get a search order, which allows you to go and not quite kick down their door, but you can go in and you can search for material and you can uplift it, hold on to it, and have it pending the outcome of the civil proceedings. You can freeze their assets up to a certain level or to an unlimited amount. You can take their passports away. You can ask them questions. You can get them in front of a judge. So it's high pressure, fun, interesting work, either for the claimant, where you are having to make quick decisions that are value judgments that may come back to bite you in the end as to whether or not you're going to go for this, whether you're going to go for this person, this form of relief. You're in front of judges arguing that on your own. Then you have, as a defendant, to decide, am I going to try and discharge this injunction? Do I think that there is information that I've got that means that the claimant has misled the court when he or she got the injunction that my defendant or my client is now suffering under? So it's high pressure work that is very interesting. You also get the big fraud cases. So at the moment, London is the centre for Russian or former Soviet Union fraud cases. They come in very different forms. The most classic example at the moment is going through the commercial court in a case called Ablyazov, where Mr. Ablyazov is accused of having taken very, very large sums of money from one of the Kazakh banks. I was involved in that case. I was involved in a case about Tajikistan. I'm involved in a case at the moment about Russia, so you become very familiar with non-European systems of law. There was a period of time where I was an expert, or thought myself an expert, in all bits of Kazakh law. And I had discussions with a number of people in chambers about Kazakh legal principles. Why on earth should I be doing that? I'm doing that because London is a centre for international dispute resolution, and lots of people want to come here to have their disputes determined. So really what I would say is commercial work is very broad. There is lots of different types of things that you can do. Almost all of it is interesting. Some of it is dull. The question of dullness is often a matter of personal perception. There are some areas where I wouldn't be seen dead doing them, but lots of people in my chambers do those areas and think that they're great fun and they enjoy them hugely. In terms of the lifestyle, I think you need to be able to drop things to do something else. It is very rare that I turn up in the morning and I do the same thing all day. I am often asked about old cases. Should we be doing this now? Should we be doing that now? Or new cases come in. So I'm sitting there thinking, well, I've got a quiet day today. And then at 10:30 in the morning, someone wants an injunction to restrain a broadcast of a television programme, or someone wants to make sure that their television programme is indeed broadcast during the weekend. So you have to get all the papers together. You have to take witness statement. You have to put a skeleton argument together. You have to get your authorities together, and you're in front of the judge at 4 o'clock to try and make sure that whatever you want, the court gives you. So it's often high pressure, but it's very, very interesting and varied work. In terms of qualities that you need, I think you need to be willing to work hard. I think you need to have a commitment to detail, and you have to want to analyse legal problems. I think if you don't have an analytical turn of mind, commercial work is probably not for you. If you want to be in court every day, commercial work is probably not for you. But if you are analytically interested and you want a mixture of court work, paperwork and hard work, then I think commercial bar is one of the best places to be.
Thank you very much. Good introduction. Thank you, Tom. Rose, can I hand over to you?
Hello everyone, I'm Rose. I'm a first-year junior tenant at 39 Essex Street Chambers, which, like Blackstone, specialises across a number of different areas of law. I thought about doing law at school and did do law at university. I did my undergraduate law degree at Oxford, and then I went to Canada and did a master's in human rights and legal theory. More on that later. And then I came back to the UK, did the BVC as it then was, and then did pupillage at 39 Essex Street. When I came into pupillage, like a number of people who you'll meet at who are specialists or thinking about becoming specialists at the commercial bar, I wanted to do human rights law. That's why I picked the chambers that I went to. After about 6 months of pupillage, I wanted to do environmental law, which was the first seat that I did. And that is another area of my practices at the moment, is I do environmental and planning law. And by the end of pupillage, by the tenancy decision, I decided that one of the things I definitely wanted to do was commercial law. So the message I want you to go away with at the end of today is keep an open mind about what areas of practice you might want to specialise in. It was very important for me that I went to a chambers that specialised across a number of different areas, so I could see a range of work, and so that I could use the experience I get, for example, traipsing up and down the country, going to county courts, doing road traffic cases and insurance cases about property damage, and apply that to the more complicated litigation where I act in as a junior, which is more commercial and doesn't involve going to court by myself a lot of the time. It's more sitting at the back of court doing work while I watch my leader do the advocacy. So that was very important to me. That might not be something that's important to you, and there are a number of specialist commercial sets out there. When you make your pupillage applications, it's a personal decision as to whether or not you only want to apply to do chancery work, or you only want to apply to do construction work, or you definitely want to go to a mixed set of chambers. But it's something to think about for longer than 5 minutes, is to exactly the kind of experience you might want to have as a pupil before you go off and make your applications. Because I think myself And some of my colleagues at this table are prime examples of someone who thought they might want to do something else. And then it turns out that the practice of law is quite different from how you think it might be. So as far as what I do on a day-to-day basis, as I said, I'm a first-year junior tenant. I'm still doing everything that my chambers does. And a lot of the times I'm doing what my clerks tell me I have to do. So a typical week for me is spending 3 or 4 days in court doing a trial, which could be about a small contract dispute or a small commercial matter, could be about a road traffic accident. It could be a planning inquiry, which is also something that I do. In addition to that, I'm instructed as a junior on a number of cases across commercial construction and environmental law. I'm one of 10 lawyers currently working on a massive commercial arbitration it's a building dispute basically, about someone built something, the employer on the contract didn't want to pay, so they sued them, and then the employer said, well, your work wasn't very good anyway, and that's basically the dispute that they're having. I'm instructed on another similar case about a building dispute, and also an advisory case about environmental law. So I have quite a mix of the things I do, and it's true that I don't do the same thing every day, and weeks are quite different from one another. Focusing, I suppose, on my commercial work, because that's what you guys are here and are interested in, I do some paperwork, so I do pleadings in small commercial matters. I do one-day trials or small applications for things that are part of a bigger case, so an application for disclosure, enforcing a judgment from a case that's already happened, applications for injunctions, and that kind of thing. And then also I spend time as part of a team doing more paper-based work, which can be reading papers for a disclosure exercise, writing or helping to write witness statements, or at the moment I'm helping to write the closing submissions for an arbitration that's taken 4 weeks. Writing those closing submissions is going to take 3 weeks, and it's going to take up quite a lot of my time in that period of 3 weeks. So the workload is quite heavy. You do end up staying late in chambers quite a lot compared to your colleagues who might have a different kind of practice. And it is something that you have to be prepared for, especially when you're a junior. You're not necessarily always in control of your own time. One of the best things about being a barrister is that you're self-employed. You can come in when you want, you can leave when you want, as long as you get your work done. As a junior in a commercial practice, that's not always the case. And it's something to be aware of, that if you do want to be your own master, think hard about whether or not you want to be junior number 5 in a massive commercial case, because there will be times when you have to drop everything and do something last minute for your leader. There will be times when there just aren't enough hours in the day to get something done. Now, that doesn't mean that I'm not happy. It doesn't mean that I never sleep. What it does mean is that I get incredible amounts of job satisfaction from what I do, because I see the products of my hard work going into a much bigger case. I'd never, ever have the opportunity to do these big cases on my own. You have to work in a team. And it's really great when you are sitting at the back of a tribunal and watching your witness get cross-examined on a witness statement that you helped him write. Because you know what his answers are going to be, and you know when the advocate on the other side asks questions, you're like, oh, I know the answer to that, he's going to get him. So you do get incredible amounts of job satisfaction, and that's one of the reasons why I really like commercial law and why I like working on big teams especially. As far as lifestyle as well, my set's quite rare at the bar, in that we do specialise quite a lot in construction law, and there are a number of different sets that do that. We also have, is worth mentioning, a lot of people who are parents who are specialists in commercial law. So it's not incompatible with having a life outside of the bar, and it's very important to remember that. But it does mean that there has to be some negotiation every now and again as to when you have to work late, when you're away on a case for a certain period of time, you are away from your family. And sometimes you do have to do things last minute. But if you're interested and if you're committed, it's not incompatible with having a family or having a family life outside of chambers. As far as what qualities I think you need to have to be a commercial barrister. Attention to detail and an analytical mind is very important. One of my sort of favourite things about the law, which is why I studied law at university, was I really like reading cases, building arguments from cases, and be able to build arguments that are potentially not supported by case law but might be worth a go. So that kind of creativity is also very important. In addition to that, one of my favourite things about commercial law is that things tend to go wrong quite a lot of the time. So you do need to be calm, and you need to have enough people skills to be able to explain to your solicitor or to your client that yes, things have gone wrong, but it will all be okay if we do this, this and this. Or potentially, yes, things have gone wrong, it won't be okay, but this is how we try and fix it. So there is, whilst lots of people think that commercial barristers might just be a brain in a box, that's definitely not the case. You need to have a practical turn to be able to see problems coming, or when problems occur, to be able to look at ways of fixing them and trying to get the best outcome possible for your client. That's also what makes it fun and exciting, is that unexpected things pop up. And that's one of the reasons why I'm hoping to specialise in commercial law down the line. So I think my general message to you is go out, see the world, think about what sort of areas of law you might want to do, but don't rule anything out at this stage, because you just don't know what you'll end up liking, and you just don't know what you'll end up specialising in.
Thank you, Rose. I think that's really good advice about when to think about sort of areas of practice. So I'm going to Ben Smiley now, who's going to talk about his practice.
Hi, apologies at the back. My throat is going after manning a stall for an hour and a half, so if you can't hear me, do put your hand up and I'll try and raise my voice. My name is Ben Smiley. I'm at 4 New Square. I'm also a first year tenant. I didn't know I wanted to be a barrister at an early age, and I didn't want to do a vocational course when I was choosing what to do at university. So I was always interested in the way society works and the way society should work. So I studied politics, philosophy and economics at Oxford, and then reached that stage in your third year, you may all have reached that, where you think, God, what do I do next? And I hadn't done any internships, and I hadn't decided I wanted to go into the city, thankfully. So I did a few mini pupilages, and I did them at a media set and a criminal set. And I loved them. I thought they were incredibly exciting, really interesting work, people standing on their feet, declaiming these really, really interesting arguments. But I couldn't really see myself doing those jobs. I don't know if any of you have done criminal mini pupilages yet, but it's a very different lifestyle to a commercial lifestyle, and the arguments that they're dealing with are very different, as Tom's explained. So I knew I wanted to be a barrister, but I didn't know what kind of barrister I wanted to be. But I thought, well, that's fine, I'll work that out on the way. And so I did the GDL and did a number of more mini pupilages in a lot of different commercial sets, and realised that that's what I wanted to do. And then I applied for pupillage, did the BBC, got a pupillage at 20 Essex Street originally, which is a really great shipping and public international law set. I spent 12 great months there, learning an awful lot about myself and an awful lot about shipping law. I decided I didn't want to do shipping law, and they decided they didn't want me to be a tenant there, so that worked out nicely. And then applied for a third six at 4 New Square. And the reason I chose 4 New Square is because it does, as Blackstone and 39 Essex Street, it does a lot of different kinds of work. Its main area is commercial law, and within commercial law, its main area is professional negligence. And it's professional negligence that really drew me to 4 New Square. Professional negligence work is the real perfect, in my mind, balance between heavy, interesting, factual cases with a real personal element to them. At the heart of all these cases, there's a client who's gone to a professional because they want them to help them. And then they feel that the professional hasn't helped them quite in the way they wanted them to. And I found that really appealing. But it's also got that element of all commercial cases of real law, real analysis, and real bookwork that Tom spoke about. And so that's why I applied to 4 New Square. And then what types of cases I'm involved in? Well, we've already heard a number of different types of cases that commercial barristers can be involved in. I, at one end, am the junior on a massive $400 million claim by a Central Asian country against a mining company. Arguably, the country drove the company out of it, arguably. And at the other end, yesterday, I was in Medway County Court dealing with a road traffic accident over £900. So it really is an enormous range of the amount of money and the kind of case that you're involved in. I'm also currently on secondment at the FSA. Lots of these chambers do secondments. I'm doing a secondment with someone from Blackstone. So that's something that you can often get at the early stage of your career. And it's a really good opportunity to learn a lot about particular areas of law. So being at the FSA, I'm learning a lot about financial services regulation. I'm also learning quite a lot about office politics, which is less fun. And that's one of the great things about the bar, is that you are self-employed. You do have the chance to be your own person, and can avoid to a certain extent office politics, so that sometimes always manages to creep in. What I find appealing about the area of practice, I've sort of covered that, but I think the breadth of the commercial bar is its main asset, that you can do anything you want: insurance, professional negligence, banking, and each of these has their own different people involved in them, the law involved in them, and the cases that happen. Within professional negligence, one of the real bonuses is the variety of professions there are out there. I can be dealing with an accountant one day and have to learn all about his area of practice and the law around accountancy, and then a solicitor the next day. Hopefully I know enough about the law to deal with that. In my chambers we do a lot of sports work as well, and you can learn all about the disciplinary rules and the rules of that particular sport. So there's lots of different variety, and it means that every day is a different day where you're doing a different thing, and you have to drop things very quickly, pick things up very quickly, and be able to take on board new principles and new facts in a very short period of time. Perhaps not quite as short a period of time as if you were a criminal barrister, because you do have certainly a longer lead up to your cases than you would as a criminal barrister, where you're doing a different case every day. But there is still that every case is different and has different facts and has different law, and I find that a real bonus. The lifestyle implications, it's quite a weird question, that, but I love my lifestyle as a commercial barrister. I love the sound of my own voice, perhaps less today than usually. I love being on my feet. I think anyone who wants to be a barrister wants to be an advocate, and that's what draws you to the bar. But then within the bar, there are so many different kinds of areas that you can practice in, and they each have their slightly different balances. As Tom's already explained, I think I have probably a 60% paperwork, 40% court work balance when I'm not on secondment. And I find that absolutely perfect for me. It means I get the chance to go into court, hear either my arguments or the arguments of the silk that I'm being led by. Quite often he's delivering my arguments, and that's quite satisfying, as well as hearing him pinch a witness that I gave him the questions to ask. And then there's the paperwork. I found at university that for the first 2.5 years I had fun, and then for the last 6 months I worked incredibly hard, and found that working really hard, reading into these incredibly impressive philosophers and political analysts, I enjoyed bookwork. And I think to be a commercial barrister you have to really enjoy analysing arguments, picking them apart, putting them back together again, and coming up with your own view. I think one of the joys of being a barrister is you sometimes have to put together an argument which you disagree with, that you know is wrong, but you have the intellectual flexibility to come up with an argument that goes against everything that you personally believe in. That hired gun element I find very enjoyable. But you do have to work hard. Long hours, over weekends, late nights. But if you're doing what you enjoy, I don't think that should be a problem. And I think when you compare being a barrister to any other job that you're potentially interested in, you always have to work hard, and as long as you're doing the job that you enjoy, that shouldn't be a problem. What the key skills and personal qualities are? Well, intellectual ability we've spoken about, and I think the next thing is really the ability to express yourself, not necessarily orally. Lots of the best commercial barristers actually have quite bad delivery. You know, they have stutters, they have stammers, they are quiet, they're a bit hesitant. But the arguments that they're delivering are so good that the judge who hears it just has to accept it. And I think that's obviously something you can bear in mind. You needn't be the most fantastic orator to be a brilliant barrister, but it helps. And if you are a debater or a mooter, even public speaking in general, that can really help, because especially at the bottom end, you're dealing with district judges who perhaps don't get the nuances of your argument, but are impressed by the rhetorical flourishes, sadly. So those are the key things, and then the ability to work hard. I think we've covered that, but I think it is key. And I think a real interest, talking about how to get a pupillage, which we haven't covered in too much detail, but I think if you want to be a barrister at a particular set, you should work out what the set is like. And I don't mean just purely in terms of work, but also in terms of the people there and the atmosphere there. And I think mini pupillages are invaluable for that. But also, if you're applying to a particular set, there's nothing they'll like more than you having taken an active interest in the work that they do. Almost all of our websites will have articles about cases we've done. 4 New Square tweets, so you should follow us. And if you can raise a particular case that someone in Chambers has done and say what you think about that, I think that will show real interest in the Chambers and in the work that the Chambers does. And it'll show that you've kind of done more than the average, oh, you do commercial, how interesting, this is exactly what I want to do. So that's my main advice. Do some proper research and work out what it is that you want to do and the kind of people that you want to work with.